Hey guys, what's up? So this is the Fundamental Rights 3.2. This is the Polity series. If those of you do not still know where we are, so in Polity series we have covered part 1.1, 1.2, 1.3, 1.4, and then we had part 2.1, and then we had part 2.2. So now we had part 3.1. So watch these all these parts before coming here, because all these are relevant and they make a uniform cohesive understanding before you can proceed. If you watch this video before watching them, it will be a bit of a problem. Fundamental rights are by far the best part, which is the most high yield part in entire polity series. So do watch them, and this is presented by me, and this is the YouTube channel Unacademy. So if you want to read more about me, this is it, and you can also Google it and you can read various articles. And this is the Facebook page, that is facebook.com/romansaini.official. Like it to stay updated with the recent videos. Do subscribe to the channel as well, and do share it as much as possible for the benefit of those who do not and cannot afford coaching. And finally, message me your query in the comment section on YouTube and Facebook, because that is the only part where I'm going to look. Do not message me on my profile, it's not gonna be looked by me. So anyways, moving forward, we start with the definition of state. What is a state under Article 12? So what is a state? So state is not merely state. State includes everything. Just read this line. It is extremely wide and broad interpretation as far as state is concerned. So it includes government and parliament of India, that is all the executive actions, as well as the legislative. Legislation is parliament, government is executive. Similarly, legislature of states as well as the government, so both are understood. So this is what we consider by state. But now comes the third tier of the government, that is municipalities and panchayats, district boards, improvement trust, etc. All local authorities are also included under it. Then we have all other authorities, that is statutory as well as non-statutory authorities like LIC, BHEL, SAIL, GAIL, TAIL, everything is included under it. Even a private body or an agency who works on a contractual basis or working as a state agency is also included under the definition of state. So if these bodies violate your fundamental rights, only then you can invoke Article 32 or Article 226. Is that 100% understood? If a private individual accept Article 17, Article 24, if these are violated like Article 21, so a private individual cannot practice untouchability, and you can go to the court and it will not be unheard on the ground that it is against a private individual. Most of the rights have to be violated by the state, only then Article 32 or 226 arises. Otherwise, only against private individuals fundamental rights can be violated, and only ordinary legal remedies are available. So it is the action of these agencies that can be challenged in the court as violating the fundamental rights. So Article 13, it deals with the laws which are inconsistent with fundamental rights. So what do you mean by law? So definition of law is given here. Just see. Permanent laws, obviously, which are enacted by parliament or state legislature. This is absolutely understood. These are what we call as law. Second is also understood, temporary laws like ordinances issued by the president or governors. Is that understood? Obviously, yes. Now comes the important part, delegated legislation, which the executive like bureaucrats, IAS, IPS, IFS, they do it. So they have order, bylaws, rules, regulations or notifications. So they are also included under the law. So they had to be statutory. And finally, to wrap it all up, non-legislative sources of law like local prevailing customs or usage having the force or seeming like a force of law are also included under law. So any law which is inconsistent with fundamental rights is totally violated and totally becomes null and void, and this gives the power of doctrine of judicial review. Very important. So all laws that are inconsistent with or in derogation of any of the fundamental rights shall be considered void. Supreme Court under Article 32 and High Court under Article 226 can declare a law unconstitutional, invalid, void, null on the ground of contravention of any of the fundamental rights. Now what about Constitutional Amendment Act? So now this is the important point. Constitutional Amendment Act is not a law under Article 13, and hence it cannot be challenged. It was the position till 1973, 24th of April. What happened on this date? Sachin Tendulkar was born, so the position was changed. That was also one of the reasons, but the major reason was the case one and the Bharti case. So that a constitutional amendment act can be challenged on the ground that it violates basic structure of the constitution and the fundamental rights, since they are the part of basic structure of the constitution. So doctrine of judicial review applies also on the constitutional amendment act. So India is one of the rarest countries where constitutional amendment, which is so difficult to come about, where two-thirds of the majority is required, and in many cases, right now we have 29 states, so 15 state will be required. Are you understanding this? So highly difficult, and even then they can undergo judicial review. It is never seen in any constitution of the world that judicial review overarches over the Constitutional Amendment Act, except in India. So we will deal with Article 32. So I have dealt with Article 12, Article 13. I have also dealt with Article 31. I have dealt with Article 33, Article 34, 35. So only the major fundamental rights are between 14 to 30, and Article 32 will be dealt. So this will be dealt in the part 3 if it ever comes. I don't think I'll be making it. I think you should read from your books. Anyways, it's your choice. If you want me to make it, I will do it for sure. So like the video and do let me know in the comment section below or on the Facebook post whether you want this part also to be covered by me. So right to constitutional remedy. So why it is there? So according to B.R. Ambedkar, mere declaration of fundamental rights is meaningless, it is worthless, it is useless, and it is without providing an effective machinery for their enforcement. So it is absolutely essential, right? So Article 32 is right to remedies for the enforcement of fundamental rights of an aggrieved citizen. Just remember this word, citizen. So right to get the fundamental rights protected is itself a fundamental right. Are you getting? It's like the double protection provided to you. So if you go to Supreme Court under Article 32, Supreme Court cannot refuse if your fundamental right is violated. However, if you go to High Court under Article 226, High Court has a discretion whether to entertain or not. That is why fundamental rights are totally defended by the Supreme Court, not High Court. Dr. B.R. Ambedkar called Article 32 as the very heart and the soul of the Constitution. It is the most important article of Constitution. MIA means missing in action, but here it means most important article. So an article without which this Constitution would be a nullity. Then Supreme Court under Article 32 gave it as a basic feature of the Constitution. So no matter what you do, it cannot be removed at any cost. So even if there is an amendment, it cannot be decreased in power, it cannot be abridged, and that is why it is a part of basic structure of the Constitution. Then Article 32 contains the 4 provisions that you can move to the Supreme Court for the enforcement of the fundamental rights. Okay. Then Supreme Court have the power to issue directions, orders or writs for the enforcement of any of the fundamental rights. Okay. Parliament can empower any other court rather than High Court and Supreme Court to issue writs. Okay. And the right to move Supreme Court shall not be suspended at any cost except by the President under national emergency by Article 359. Is that understood? So Article 32 is more or less sacrosanct except under Article 359. So Supreme Court has been vested with original powers. Original, what do you mean by original? That is, you can directly approach with or without appeal. Is that understood? You can also go by appeal, that is from High Court to Supreme Court, or you can also approach directly. So we have original powers, and it is wide powers because not only orders and directions but also writs can be issued to provide a guaranteed, effective, expeditious, inexpensive and summary remedy for the protection of fundamental rights. So this is how answer should be written: guaranteed, effective, expeditious, inexpensive and summary. So only fundamental rights can be enforced under Article 32 and not any other right, like non-fundamental constitutional rights, statutory rights, customary rights, etc. So these kind of rights cannot be enforced under Article 32. Is that absolutely understood? Now, only the fundamental rights. So jurisdiction of Supreme Court is original but not exclusive. What do you mean by this? High Court can also issue writs under Article 226. That is, you can directly approach to High Court or Supreme Court. Finally, where relief through High Court is available under Article 226, you should first approach the High Court according to a Supreme Court ruling. Then writs are total 5 in number. Supreme Court under Article 32, High Courts under Article 226, that is all the High Courts of the India, can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. So Parliament under Article 32 can empower any other court also to issue. It is not done till date, so only High Court and Supreme Court can issue these writs. Power with respect to writ jurisdiction includes, it is limited to fundamental rights for Supreme Court. So what is the difference between Article 32 versus Article 226? This is the main question here. For Supreme Court, it is very narrow, that they can include only fundamental rights, while for High Court, both fundamental rights as well as legal rights, they can issue writs. So for Supreme Court, territory is wider because it includes entire India. For High Court, territory is very small. It includes usually state plus, let's say for West Bengal, Andaman and Nicobar will be included. For Kerala, Lakshadweep will be included. Plus, if the matter really extends to the other area, they can be included, but usually the state. Then High Court may refuse, that is, it has discretion. Discretionary powers are there. Discretion is present with High Court whether to entertain it or not under Article 226, because Article 226 itself is not a fundamental rights, but Article 32 being a fundamental rights itself, Supreme Court cannot refuse. That is, Supreme Court is ultimate defender and guarantor of fundamental rights. This question will come in mains. So habeas corpus, so you will see this word and you might have to write words. So by habeas corpus, I just remember habe, so I remember have. Corpse means corpse, so I remember body. So have a body. Is that absolutely understood? So just remember have the body. So present the body if you have detained illegally. So order will be issued by the court to a person who has detained another person to produce the body of the latter before it. It examines the cause and legality. If it is found illegal, it will be set scot-free. So it is protection of individual liberty against arbitrary detention. It is both against state and private citizen. So what is locus standi? Locus standi means if I am the aggrieved party, I can only go to court saying that this fundamental rights has been violated. But principle of locus standi do not apply in habeas corpus. Since I am already under confinement, I cannot go to court saying that I have been under confinement, so present my body. So principle of locus standi do not apply, and it cannot apply logically. Finally, writ is not issued when the detention is lawful or legal. It is related to contempt of a legislature or court. It is detention is by a competent court, and it is outside the jurisdiction of court. Mandamus means, I remember only mandatory. Mandamus means literally mandatory, that is mandatory duty. So it means we command. So it is a command issued by the court to a public official. Just remember public official, asking him to perform his official duties that he has failed or refused to perform. It can be filed only by aggrieved person. So principle of locus standi applies. That is, only an aggrieved person can file. However, writ cannot be issued against a private body to enforce departmental instruction that are not statutory when the duty is discretionary and not mandatory, to enforce a contractual obligation, and finally against president, governor, chief justice. So is that understood? Now moving to the third, that is prohibition. Prohibition is very simple, to forbid. That is High Court forbidding a lower district court or session court to usurping its jurisdiction. So it is issued by a higher court to a lower court or tribunal also to prevent the latter from exceeding or usurping its jurisdiction. Then writ of prohibition can be issued only against judicial and quasi-judicial authorities, not against anyone else. Then certiorari means certificate or information. So by a certificate you inform them कि भैया, if you have given an order, it will be quashed, or if you have not given an order, the case will be transferred. So to be certified or informed. Issued by again higher court to a lower court, also only against judicial and quasi-judicial bodies, to transfer a case or to squash the order. Again the same grounds, excess of jurisdiction or error of law or lack of jurisdiction. So prohibition was only preventive. Certiorari is both preventive and curative. Preventive means if the transfer of case happens, no error happened, so it is preventive. However, if the already order was given, it will be squashed, so it is curative. So till recently, the writ of certiorari could be issued against judicial and quasi-judicial authorities. It now includes administrative authorities as well. Please make sure you remember this. Certiorari can be issued against administrative authority, while it cannot be issued in case of prohibition. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. So what can be issued against administrative authority? Certiorari, not prohibition. And finally we have quo warranto. It means what is your authority. Quo means what. Warrant means by what warrant are you sitting on the office. So by what authority or warrant? So it is issued by a court to inquire into the legality of a claim of a person to a public office, and it prevents illegal usurpation of public office by a person. Is that understood? It prevents illegal usurpation of public office by a person without any requisite qualification. You cannot hold a public office. And writ can be issued only in case of a substantive public office of permanent character, not a temporary, very low level of office. And it has to be created by statute or by the constitution, and it cannot be issued in case of ministerial office or private office. Then finally we will deal with present position of right to property. So originally fundamental right was given right to property under article 19(1)(f), which guaranteed every citizen of India the right to acquire, hold and dispose of property. Okay, and article 31 guaranteed to every person including aliens right against deprivation of his property. Only on two conditions state can take their property. It should be for public purpose and it should provide for payment of compensation amount to the owner. Lot of controversy emerged because any law which was passed was contravening to right to property. So the first Constitutional Amendment Act introduced 9th schedule, article 31B, which said that even if fundamental rights is violated, any law which is kept under article schedule 9 will not be under judicial review. So any law which is passed before birthday of Sachin Tendulkar or the Keswanand Bharti case will not be under judicial review. However, after the Keswanand Bharti case, even under schedule 9 it can be reviewed by Supreme Court. So it introduced article 31A, which deals with estates, 31B schedule 9, and C with DPSP. So even if the law is violating these fundamental rights and the law is giving effect to these three, it cannot prevent judicial review. So finally, because of these controversies, 44th Constitutional Amendment Act was introduced. It removed article 19 clause 1 subclause F and article 31 completely. It introduced article 300A in part 12, right to property. It simply reads, no person shall be deprived except by authority of law. So the legal right was made, fundamental right converted into legal right. So what are the implications of this? It does not become a part of basic structure of the constitution, first of all. So no need of Constitutional Amendment Act. It can be regulated or modified by ordinary law. First thing is this. This is a very, very important part. Legal right versus fundamental right. So only ordinary law because it is no longer part of basic structure. Second point is protection only against executive action. Fundamental rights is protected both against legislative and executive action. Then Supreme Court under Article 32 cannot do anything. Even High Court under Article 226 is not bound. It has two discretion powers. And finally, there is no guaranteed right to compensation and state can take away your land without compensating you. But since the law has been introduced now, so it cannot be done. What is the exception to the state acquisition? So these are the two cases where compensation is guaranteed in case of acquisition or requisition of the private property by the state. First point is when the state acquires the property of a minority educational institution under Article 30, and secondly, if a personal cultivation land is acquired and it is within the statutory ceiling limits under Article 31A. So is that understood? So if you want me to make the part 3 on the fundamental rights, do let me know. Fundamental rights are absolutely fundamental for your preparation also. So without this you cannot do anything. Do hit the like button if you enjoy the video, and yes, if yes, that is the part 3.3. If you want it, then comment and let me know. So anyway, this is the YouTube channel Unacademy, that is youtube.com/unacademy. This is the Facebook page, facebook.com/romansaini.official. You can also tweet to me at my Twitter handle @romansaini. Do like, share and subscribe, and thank you for watching the video. Have an awesome day.